Law guardian definition and guardian ad litem changes a little bit from state to state. But in New York State, a law guardian is assigned to represent the child once the child is of an age where they can really convey their desires and interests. And then I represent the child throughout the litigation, and I represent the child's interest, not the parent's interests. A guardian ad litem is assigned for a child who's too young to express an interest. For example, an infant would be assigned a guardian ad litem. And then I'm permitted to assert my opinion about what should happen with the child based on the information I receive from other sources. Different states interchange the term law guardian and guardian ad litem. So for example, in another state, they may call what we would call a law guardian a guardian ad litem. And so you have to be certain what each state, what your state defines as a law guardian versus a guardian ad litem. All states have both a guardian ad litem and a law guardian in terms of the role that they play, even if they don't call them that. So they'll call them something else, but the roles will be defined in that manner. A guardian ad litem or a law guardian can be selected by the court, by the judge, in a case where the two parents are fighting over custody and parenting time. Or one or the other parties can request a law guardian or guardian ad litem because they think that the child's interests are not being fairly represented. The only way you can avoid having the judge appoint an advocate is if you agree, come to an agreement. And if you don't come to an agreement, the judge is going to have to appoint an advocate for your child. So sometimes parties who are even really hostile to each other can engage in some mediation process, and that helps them. That's often better than having the court appoint a law guardian because the parties have come to terms themselves with the help of a third party. But if there's, physical violence, drug abuse, alcohol abuse, issues like that, a court may decide that no matter what you agree to, they still may appoint a law guardian to be certain that the child is safe with that other parent and to try to determine whether or not that parent is fit to be the decision maker in the case. So for example, the parties may want, I have a case where the parties wanted the mother to be the decision maker, but the mother had a mental illness. And so the judge wanted to be certain that the mother was capable, and so she appointed a law guardian. That's an example. A judge will request a law guardian be appointed usually when he or she sees that there is no way to settle the parenting time in custody. And often that does not happen the first or second time on in court. Courts want to keep suggesting to the parties that they try to resolve it themselves, try to mediate it, perhaps some family therapy, some counseling, so that they don't have to put the child and the family through this very expensive, costly, and traumatic experience. However, after 2 or 3 adjournments, usually it's clear whether or not this case is going to be settled, and then the judge will tell the parties that he or she is going to appoint a law guardian. Usually it is the same attorney hourly rate as they are paying their attorneys. So depending upon which state you're in and how much you're paying your attorneys, the level of their hourly rate, it will usually be reflected in a similar hourly rate for the law guardian. So for argument's sake, let's say that you're paying your attorney, for example in New York, $350 or $400 an hour, it is very likely that the law guardian will be charging something similar to that. If you're in a different state where fees might be a little less, let's say it's $200, $150 an hour, it will very likely be similar to what you're paying your attorneys. But in addition to that, you have to remember that not only will a law guardian be appointed, but you often will have to get a forensic evaluation from a psychologist or a psychiatrist, and that is an additional expense. Sometimes it happens that a party will use that as a strong arm tactic, the selection of a guardian ad litem or a law guardian, because it's expensive. They have to pay another attorney, and usually both parties have to pay in proportion to their income. It also means that the litigation will be protracted. It'll go on for a much greater length of time. And sometimes they think that the other party will be intimidated and fearful that a law guardian may discover things about them that they don't want publicized. I think that if you need a law guardian or a guardian ad litem, it means that you're having a problem with coming to an agreement about what should happen with your child. That's never a good thing. The best thing is for parties to agree between themselves to make their own decisions for what's best for their child rather than a court making that decision. So it is an indication that there is something breaking down in that process of communication. That being said, it sometimes can be a very positive thing because I have negotiated settlements with parents and settled cases rather than litigating cases because I'm in the position of not being one or the other of their advocates, but really advocating for their child, and most of them really do love their child. So I can be almost a mediator in a sense and suggest maybe to one or the other that there can be compromise here and ultimately settle the case. They also tend to believe, parents tend to believe me if I am asserting a particular position for their child because they feel like I do have the child's best interests at heart, and hopefully the child is communicating honestly to me.